When's your birthday, boss?
Sir, I'm not answering no more questions. I need to call my attorney.
Well, your attorney, that has nothing to do about your birthday.
So he wasn't under arrest?
Like I said, I'm not sure at that time.
Who detained him then?
My partner.
What is required for any assault in Michigan is common case in law, intent. The officer said on the video and confirmed under oath, we didn't think you intended to do it or anything. There goes their case. Gone. It's over.
I have ticket number P1634806, which is City versus Malcolm Talley. We'll go through the facts in a moment, the procedural facts. And then I've got P1786185, which is also City versus Malcolm Earl Talley, both having to do with the charge of carrying a concealed weapon while under the influence. Good afternoon, Officer Stearns. Good to see you. Yep, go ahead and have a seat. Thank you. Hi, Ms. Horn.
Thank you, Your Honor. Thank you, Officer Stearns, for your dutiful service. And on June 2nd, 2025, at approximately 1 or so a.m., were you on duty?
Yes.
And were you on duty in the area of East Larned and Beaubien Street?
I was.
And what brought you to the area?
We were stationed there for security.
Okay. And what kind of security was needed for that particular area?
The night before, they had I believe it was a clock switch coming to the parking lot, so they want to heighten security. So my partner, myself over there, NPO van, it's called neighborhood police officer van.
Okay, I think you have to speak up.
Are you have to
Can you hear me?
Yeah.
Is that better?
Or you can even hold it.
Yeah.
Just speak as loudly as you can, if you don't mind. I know I feel like I'm yelling in here a lot. But
So we were stationed over there due to an incident the night before.
Okay. And what brought your attention to this particular incident? What were you doing at the
So my
time?
partner and I were just watching traffic drive by. It was kind of a slower night. And we saw 3 gentlemen stand over by I believe it was a black like SUV, and we were just watching them. And then the middle, I believe it was the middle gentleman, Mr. Talley, he turned around. And we watched what appeared to be an AR style weapon mounted light flash up.
And what's the AR style?
An AR style. So like you know what M4 is?
Kind of like a,
Yeah, it's like a rifle.
okay.
Similar to a rifle.
Okay. And what was you noted something about the rifle. What was distinguishable?
It had a weapon mounted light on it.
Okay, and when a weapon has a light on it, where is it usually placed?
It's placed in the picnic rail.
And what?
The picnic rail follows the barrel.
Okay, and it's you're saying that you observed the light,
Yes,
and what? Where was the light pointing?
at us.
Directly at you?
It swung. So if you're looking at our van, which was also captured on green light camera, it swung up, it cut right back down, and then immediately Mr. Kelly turned around, put the rifle back in the backseat.
And at that point, what did you do?
We went over and started talking to him, just make conversation with him.
Okay, and is that person who you approached in the courtroom today?
Yes,
And can you identify something about what this person has on?
Mr. Kelly, right there has the black and white jacket on.
Okay. Your Honor, may the record reflect that the officer has identified the defendant.
record will so reflect.
Okay, thank you, Your Honor.
Mhm.
And what did you say to him once you approached?
Basically, I was honestly just trying to have a civil conversation. Like, hey, like, did you point a light, a weapon at us? I explained to him what the weapon mounted light. At first, it was kind of like back and forth, and then, I think it was I forget the exact time, but he told me, he's like, yeah, I do have a rifle, a 300 blackout. And I was like, does it have a light on it? At this point, we pulled over, got out of the van. It just went from a civil conversation to Mr. Kelly kind of becoming irate, and I was like, don't want it to escalate. Let's get out and talk to him.
And at that time, did you have any camera capability uniform on?
Body worn camera, yes, ma'am.
Okay. And was it on at the time?
Yes, ma'am. Sorry, 104.
Okay. And after that, what happened?
My partner, Mr. Kelly, actually retrieved the weapon, passed it to my partner, and then Rock 60, which was Sergeant Honeycutt at the time, showed up, and Lieutenant Ravier and another lieutenant made our scene. At that point, we became Mr. Kelly and retrieved his weapon. He had another weapon on his waistband as well.
And did he disclose the weapon at the time you initiated conversation that was on his waistband? And how did you discover it?
When I did the packet on.
And after that, what happened with Mr. Talley as far as in police custody?
Yes, Mr. Kelly was placed in the back of a transport vehicle.
Was he arrested at the time?
He was being placed in the back to be transported to DDC.
Okay, and,
Your Honor, I would object and ask for clarification. The prosecutor asked, was he arrested at that time? The witness did not answer. I think we deserve an answer.
The objection is sustained.
okay, thank you, Your Honor. Was he arrested at the time you put him in the back of the police, van?
He was not free to go, yes, sir.
I'm sorry.
He was not free to go. Yes, sir.
Okay, and so when they're not free to go and you're investigating, what is that called?
What's that?
What is that called?
He would be arrested,
Okay, so, you state he was arrested.
detained, arrested. However, he's not free to go at that time, but he was placed in the back of the transport van in handcuffs.
Okay, and, at that time, had you read any rights when he was put in the van?
No.
And, would it be safe to say you're saying detained?
Yes.
Or you said he was under police custody?
Yeah, he was not free to go.
He was not free to go. His rights were not read.
Correct. Not by me, at least.
Okay.
May the court ask a question of clarification? Was Mr. Talley handcuffed at that time?
Yes, ma'am.
Okay, thank you.
Thank you, Your Honor. And at that time, during the investigation, did you talk about anything else that you were concerned about?
Just had a radio on him, bulletproof vest, stuff like that. I mean, nothing crazy. I mean, he definitely was under the influence. I mentioned that to Lieutenant Ravier. And at that point, he was administered PBT by Sergeant Willie, I believe.
Okay, thank you. And we'll leave that there. And what made you suspect that he was under the influence?
Once I got him out, I believe it was a retrieved wallet. I might stand corrected on that, but once I got him out, I smelled it. I was like, man, like he's definitely got the odor of alcohol in his breath. So.
Thank you. And at that point, after that part of the investigation where Sergeant Ravier dealt with him, what happened after that?
One more time.
After Sergeant Ravier dealt with him with the testing of what we were doing there,
Yeah.
what happened thereafter?
He was transported to the Detroit Detention Center.
And did you accompany them to the Detroit Detention Center?
No, ma'am.
Okay. And do you recall what officers did accompany?
Yes, ma'am. Sergeant Cox, or I'm sorry, Officer Cox, and get the other officer's name.
Okay. Okay, thank you, Your Honor. No further questions at this time. Thank you.
Thank you. Attorney Whitey.
At what point was my client under arrest?
I would say once the handcuffs were put on, he was not free to go, sir.
Okay, so he was arrested on the scene prior to be placed in the police van, correct?
Yes,
And what was he placed under arrest for?
FAPO.
Okay, felonious assault on a PO. Any other charges he was arrested for at that point?
At that time, no, sir.
Was he ever under arrest for brandishing a firearm?
No, sir.
Was he under arrest for being under the influence, being 0.08 or more blood alcohol content while being in possession of a firearm?
He did not go over 0.08, so no, sir.
Okay, so he wasn't under arrest for that, correct?
No, sir.
Okay.
That was an additional charge, sir.
Okay, fair enough. So fair to say that the only charge that he was placed under arrest for at that scene was for felonious assault on a police officer, correct?
My initial charge, yes, sir, but the additional charge would be carrying concealed while under the influence, yes, sir.
Okay, so that was the additional charge, correct? The carrying concealed under the influence?
Last week, yes, sir.
Okay, and are you stating that that was a misdemeanor? Or are you stating that's just the civil infraction?
Well, again, with our system, it prints off as a misdemeanor, sir, so that's why we get a ratio ticket as civil infraction, sir.
Okay, but sitting here today, check that. When he was placed in the van and then transported to the Detroit Detention Center, you also believed he was under arrest for having a bodily alcohol content of 0.08 or more while possessing a firearm?
No, sir. I said he was arrested for FAPO, an additional charge of carrying blood.
Okay, understand. So I'm crystal clear. The only charge you arrested him for was FA, or felonious assault on a police officer, correct?
Yes, sir.
Also known as, in Michigan, assault with a dangerous weapon under 750.82, correct?
No, sir.
Okay, fair enough. Okay. I believe he stated that you and your partner were in a scout car, correct?
You're in a work MPO, sir.
A van, okay. And you were the driver?
Yes, sir.
Okay. And you initiated a conversation with my client, is that correct?
Yes, sir.
Did you initiate with anybody else?
There was two others at the window.
Okay. Did my client tell you he had a CPL?
He never disclosed that, sir.
Oh, he never said he had a
No,
CPL?
Someone else later on in the investigation did say he has a CPL.
Okay.
He actually refused to identify himself.
Yeah, okay. And you asked his identity after you arrested him, is that correct?
Once we detained him.
Okay. I believe he stated he's not answering any questions, is that correct?
I don't recall that, honestly.
Fair enough. Okay. And fair enough to say that, well, let me back up. Let's go through the incident. So after you and your partner get out of the car, you continue conversation with my client. Is that correct?
Correct.
And then I believe you stated even 2 commanders showed up, Sergeant Honeycutt as well as 2 lieutenants.
Mhm.
Is that yes?
Yes, sir.
Okay. And you discussed the incident with them. Is that right?
Yes, sir.
And one of them actually said, that's FAPO. He's good to go. Something of that nature, correct?
I believe so, sir.
Now, at that point, did my client retrieve the rifle out of a vehicle?
Yes, sir.
And he was directed by an officer to do that. Is that correct?
I do not know that, no, sir.
Fair enough. Because you were talking to command officers, probably.
What's that, sir?
Because you were talking to command
Correct,
officers.
sir. I was
Okay, fair enough.
asking what's going on.
Okay, that makes sense.
Yes. Hear me okay?
Yeah, I can hear a lot better since I'm here. Thank you. You had a Sergeant Robinson come to the scene. Is that correct? Or Sergeant Robinson of the traffic unit came to the scene
PBT.
with the PBT. And that's a preliminary breath test, correct?
Correct, sir.
And Sergeant Robinson had asked my client to take a test, the PBT test, correct?
I wasn't there, sir. I can't testify.
Okay, fair enough, fair enough. Were you ever made, actually, fair enough, I'll leave, you weren't there, fair enough. Now, my client is placed in handcuffs and then in the back of a transport van, correct?
Yes, sir.
And it's at that point that you were asking for his ID and his wallet, correct?
Either that or just before, sir.
Okay. But didn't you and the other officers have to let him out of the van to retrieve his wallet from his pocket?
He said he had it in his hand, sir.
In his hand, that's correct. He also had a knife on him, is that right?
No, he had the mace on.
Mace, that's right, mace. And that was on him when he was placed in that vehicle, correct?
Correct.
Now, you did the pat down to find a firearm on my client prior to that, correct?
Right.
You didn't find the mace?
I thought it was a lighter, sir.
Oh, I thought it was like, okay, fair enough. And the wallet you just left on him for that time?
Truthfully, I didn't feel the wallet.
Okay, fair enough. Is the Detroit Police Department policy to remove all weapons from a person prior to placing them in a transport van?
Yes, sir.
Also remove all lighters, is that correct?
Yes, sir.
And that just, it was busy, that wasn't done, correct? Okay. When you address the odor of intoxicants or alcohol, did you state to the charge not to rack things up, but he smells of alcohol?
Yes.
Okay. So that goes to support it was a secondary inquiry.
Well, yeah, my first part of our investigation was if there was a potential threat to make sure that threat was removed. Officer safety, number one.
Okay.
So.
Okay, fair enough. Didn't you state, well, actually, I'm gonna bring you back into when you're in the police van with your partner and you first pull up to speak to my client. During that discussion, didn't you tell him, we didn't think it was intentional in reference to pointing the firearm, correct?
True.
Is that yes?
Yes.
And just so I'm clear, on the property that was taken from my client, there was a bullet resistant vest, is that right?
Bulletproof vest he did have on.
Okay.
It was never removed at the location.
Okay, fair enough. But the Detroit Police Department took custody of that?
Yes.
And they took custody of the rifle, is that right?
I personally got the rifle, the pistol, the radio, the
Okay.
CPL license.
Okay, so there was a pistol, a rifle, CPL license, and
His handheld radio.
his handheld radio. Okay, all right, fair enough.
Those
Just
were all
one
placed
moment.
on evidence.
I'm sorry.
I said that was all placed on evidence.
Okay, fair enough. Nothing further, Judge, thank you.
All right, thank you. Any redirect?
At the time that you detained the defendant, very quickly, you would not have known the blood alcohol content from the DDC results at that time, would you? So you wouldn't have known whether he was over 0.05?
No.
And you wouldn't have known whether he was over 0.08?
No.
Is that correct?
Correct.
Thank you.
Just one follow-up on that. But you did know that a preliminary breath test was taken, correct?
I believe it was mentioned, I believe.
Okay, and you did know that it was not a 0.08, the result, correct?
I don't recall that number offhand.
Okay, fair enough. Nothing further, Judge, thank you.
Thank you, Judge.
Thank you. Next witness?
Jacob Ellis, Your Honor.
Okay, thank you.
Yes.
Thank you, Officer.
Thank you.
Ms. Horn, you're direct.
Hi, Officer Ellis. Thanks for showing up today, and I appreciate your testimony. I'm going to ask you a couple questions about the incident that we're here for. Officer Ellis, where are you currently employed?
With the city of Detroit.
And how long have you been with the city of Detroit?
Coming up on 2 years this June.
And is that the Detroit Police Department?
Yes, ma'am.
Okay. And what kind of training have you received as being a police officer with the Detroit Police Department?
Other than the just state, federal laws, local laws, firearms training, rifle training.
And have you served as a police officer at any other agency?
No.
And on June 2nd, 2025, were you on duty?
I was.
And were you in the city of Detroit?
Yes, ma'am.
And the location would be eastbound Larned and Beaubien Street?
Yes, ma'am.
And at that time, why were you, about 1:00 a.m.?
Roughly, yes.
Okay, and we did establish that in the earlier testimony as well. At that time, what were you doing on duty at that time?
We were assigned, my partner and I were assigned to a downtown detail as for town 5 and 5 Adam, just securing that area.
Pull the mic.
And then just speak loudly if you can, please.
All right, we're good.
And who was your partner that morning?
Officer Stearns.
And did you observe anything that brought you to the attention of that brought this particular incident to mind?
Yes, yes. At the corner of my eye, I observed a light flashing near people's feet. And as I notified my partner to look over there, that's when the light then faced us. Decided to miss.
And when the light faced you, what kind of light was it?
It appeared to be a weapon mounted light.
And a weapon mounted light, what does that generally look like to you?
So a light that has like either a Picatinny attachment or some other way to attach a light to a pistol, rifle, anything that
And was it dark at the time?
it was.
Okay. And once you saw this light, what did you do?
First, I notified my partner.
And did you have on body worn cam at the time?
At the time, we had to turn them on.
Oh. And at that time, did you speak with anyone with your partner who was involved in this incident?
Yes.
Okay. And who did you speak with?
Spoke to Mr. Talley and I believe his co-worker.
And as when you say Mr. Talley, do you see that person in the courtroom right now?
Yes.
And can you identify something that person is wearing?
I believe that's a black, gray, and white plaid coat.
And Your Honor, for the record, this witness has identified the defendant. Also going forward, so it's not cumulative, Your Honor, we'll say that we've identified him.
All right,
Okay.
thank
No
you.
objections.
Okay,
Very
thank you,
good,
Your Honor.
thank you.
All
Mr.
right.
Talley's been identified, record will so reflect, thank you.
Okay, thank you, Your Honor. And I'm gonna place, I want to play body worn cam. Do you have any objection to playing in the courtroom?
Not at all.
Okay, and this will be the body worn cam of Officer Jacob Ellis.
All right, thank you. I just enabled screen sharing. If you're doing it through the Zoom, I don't know.
Officer Ellis, down here, as you see where I'm waving the pointer, is that your name?
Yes, it is.
And would that reflect your body worn cam?
Yes.
Permission to publish, Your Honor?
Any
No
objections?
objections.
Okay,
Thank you.
granted.
Hit your lights. Hold on, bro.
I'm Marlon.
What's going on?
Before we even got there, what's going on? I just walked up about the end of the conversation. What's going on?
So, we're sitting over there, right? Nothing, right? We've been there for most of the night.
Right.
And he pulls out his rifle, right? And then he brings it over this way, points it up. And the only reason we noticed it was, again, because of the light on the end of the barrel. Right? So, of course, we're going to make contact. So, why is he waving the gun over here?
Right.
Why is he waving it at all?
Right. About to be the police, you just doing your job.
Right.
Okay.
And like I said, we came over just to talk to him, see what was going on. And he just got super combative.
Okay. So I'm gonna just say before you talk to them, he our boss. He just got here. He getting ready to start work. He got CPO over there. I just,
Well, that's fine. I mean, I'm gonna confirm all that, but yeah. All right. Where's the rifle at?
Pardon?
Where's the rifle at?
What rifle?
Your 300 blackout that you told me that you had,
Why?
so I can see it.
And Officer Ellis, is that someone you recognize in the courtroom today?
Yes, ma'am.
Okay, and who would that be?
It's Mr. Talley.
Okay, thank you.
Record will apply.
So you can see it?
Yeah, I'm gonna run the serial numbers on it. You got a CPL?
Why you want to run those serial numbers on it?
Because now I'm confirming that it's yours, it's not stolen, yada, yada, yada. Do you have any other weapons in there, or on you?
My man, step away from that phone.
Appreciate it.
He just asked me to grab my gun.
Next time we're not gonna do it that way. Turn off the
You got CPS,
You able to run numbers? I'm gonna check the serial number on this.
Let me get the.
Which pound stuff it all? Can we have a virtual with the that checkmate? We're gonna have one to go for Epic.
Do you have a cage? No chance, sir.
Pardon?
Do you have a cage by chance?
There's a card. Who's this?
Oh, this is that gentleman's over there that decided to point it in our direction while we were sitting right over here. So,
Boy,
and then do you got a cage by chance?
I do not.
Hopefully they do.
We just had somebody update.
We go to transport one.
No,
And there was,
doing a good job. We shouldn't have.
I'll try to find a college cage at 20 hours.
Can I get some Chinese food, Danny? Like, what the fuck is going on? Hey, that's my gun, bro.
What's your call now?
Is it through your boat?
Transport two. Thank you, transport two.
Press the button.
Bro, you just digging up all this shit.
dude. Well, when we're sitting over there, and the next thing you know, we see a light flash us, and then he hurry up and turns and puts it in his truck. Okay. And there was one in the chamber. Yep, 300 blackout.
What's the serial number?
Delta, Charlie, Sierra, Foxtrot, 147111.
And Officer Ellis, at this time, as you're giving off the serial number, is that to the rifle or the firearm that was flashed at you?
Yes, ma'am.
Thank you.
Okay, look pictures there, we're rolling up.
Yeah, 65. I'm over here. Checkmate. Everything's secure. Apparently, somebody pointed a firearm. Some of the officers. Used the way to get locked up.
This is date of birth 4/23/90.
Yeah, that was just.
Hey, boss, when's your birthday? Hey, he doesn't have a cage. Hey, Stearns, no cage. There's no cage.
Hey, behind you.
Behind you. When's your birthday, boss? When's your birthday, boss?
Sir, I'm not answering no more questions. I need to call my attorney.
Well, your attorney, that has nothing to do about your birthday.
You do.
It does.
Y'all taking my firearms, y'all taking me in custody.
Okay, all right, fine. Well, he's not giving us that, so.
It's where he's got his,
And Officer Ellis, failure to identify oneself to an officer upon request, is that legal?
At this point, no.
Say it again.
At this point,
No?
no.
Okay, thank you.
Right, can I get a clarification? It is legal or not legal for what my client did?
For purposes of during this investigation, officer, should he have identified himself to you?
Yes,
And is that by law?
yes.
Thank you, Your Honor. Thank you, Mr. Booker.
Thank you.
It's got the make and everything of the gun. Purchaser Malcolm Talley.
Yo,
Malcolm Earl Talley.
I don't know.
That's his name.
He pointed a,
Hey, Stearns. Malcolm Talley.
Man, let me go.
Mr. Talley, is that your name?
Yeah, that's my.
Okay, thank you.
You want to snap a picture of the
That's it. Of course, I don't have my phone.
idiot pointed a gun at you guys?
Yes. No, me and Stearns.
If you and, what are your guys' coaches?
We're Bricktown 5 and 5 Adam.
5 and 5 Adams. It's Ellis.
You got your phone on you? Can you take a picture of that, Unleen?
Yeah.
Where were you guys at exactly?
Malcolm Talley.
Hey, where were you guys at exactly?
We were right there. We were parked right here.
And he just pointed up a level.
Yep. So we're sitting here, right? And
So they're sitting
what we noticed.
vacant lot across the street from Checkmate.
Yep. So clear line of day. Next thing you know, we just have a flashlight,
And then all of a sudden they got a flashlight.
and we look over, and he dumps the barrel down, comes behind, and then puts it in the. You got that serial number?
Yep.
Where is it at? Taurus. What happened to the mags and rounds for this?
I have no clue. Probably.
We're back here. I got it. Yeah, one in the fucking chamber, bro.
Dude, that was pointed 100% at it.
You don't notice.
The thing is, honestly, like, with our experience, like, I didn't concerned. I was like,
Here's the pistol.
listen, we haven't talked though. Did I
CPL is irrelevant if he's pointing a firearm.
Did
at
I
an officer.
not explain to you how that weapon? Did I not explain to you how I observed a weapon model light? I said every source of my flashlight.
Hey, what's this guy?
There's a weapon model light.
Malcolm Talley. Is that Tally?
Talley.
EY.
Hold on, what is it? E?
Talley. First name Malcolm.
NALCOM.
Last name Earl.
EORL.
And Your Honor, if I may, to speed up the process, I will do a playback speed a little faster.
All right, bye,
Thank you.
Thank you.
Bro, he was ever on when I was talking to him.
Sorry, address is 5306 Bedford Street, Fort Worth. Yes. 5306 Bedford. 423.
And I know it's probably, yeah. You know what time you guys called up that you had 9300 so I can put on the paper?
No. 0116. It's Malcolm Talley. Tall.
Yeah, counsel, I don't know. if
Well,
you
EY.
and Attorney Whiting, I didn't really request at this point, I can't understand anything, so we'll have to either slow it down a little
Yes,
bit unless,
I-
okay.
Better, whatever point I don't mind, I have no objection if she skips forward to whatever point you want.
Right, yeah.
So you're not fast, whatever you want to do.
Okay.
Thank you. And Officer Ellis, did anything really significant happen after this point? Was this the extent of your interaction, or do you recall more that might be captured by body worn cam?
At this point, I don't believe I had any further interaction with this.
Okay, and let me look at, I wrote some timestamps on here. Okay, I think, Your Honor, that's the end of my questions right now for Officer Ellis. My notes start at where they did place the rifles and everything, as far as where I found significant throughout the video.
Okay, very good, thank you.
Thank you, Your Honor.
Cross.
Yes. Officer, I noticed at one point, my client retrieves a rifle out of the backseat of the SUV, is that correct?
Correct.
Did you direct him to do that?
I asked him to.
Okay. Is it common police protocol to tell a potential suspect who pointed a gun at a police officer to go ahead and retrieve that firearm and give it to me?
Not usually.
Okay. So you felt comfortable enough that he wasn't a threat, like he was gonna try to shoot you or anything, correct?
I didn't want to escalate the situation.
Okay, fair enough, fair enough. But if you're telling somebody to obtain a firearm, you do not believe that at that point, that he's a threat to you, correct?
I'm sure.
Okay, so normally if somebody, if there's a firearm, that say a Detroit police officer comes across in the middle of an incident, say a fight, a domestic, we'll say domestic, and they say there's a firearm over there in that dresser drawer, would you tell that person to get the firearm, or would you go over and get it?
I would ask them.
You would ask them to put their hands on the firearm and then give it to you.
Your Honor, objection, this line of questioning is not exactly what's going on here. That's an example, speculation of what the officer would do in another type of situation.
Fair enough, fair enough. I can move on. He answered. I can move on. I made my point, I think. Now, throughout your investigation, did you come to know that Mr. Talley was working security at one of those establishments?
Yes. Let's go over it. Let's get that.
Okay. So he was actually working security that evening, from your understanding?
I'm not sure.
Okay. But you did receive information that he was working security, correct?
That he was employed there.
Employed, okay, fair. Now I noticed that you registered, or you wrote down the serial number to this rifle. Did you subsequently run that through the law enforcement information network?
I did.
And did that rifle come back registered to my client?
It did.
Fair to say that my client was placed under arrest when he was placed in handcuffs?
I didn't place him in handcuffs.
I understand that. What I asked is, when he was placed in handcuffs, was he under arrest?
I would assume he'd been detained at the time.
Well, you're assuming that, but what I'm asking, you're the police officer.
Objection,
You're on
Your
the
Honor, he's asking an assumable question. This officer did not place him under handcuffs. He was on a separate detail at that time, so he would not have personal
Let me build
knowledge.
foundation. You know, I'll back up.
Thank you.
Build up.
Okay,
Did you see my client placed in handcuffs?
No,
Okay. Were you the arresting officer, or was your partner technically?
my partner.
Now, when you asked my client for his date of birth, do you remember that testimony where the prosecutor asked you if that was lawful or not? Is that correct?
Correct.
You agree with me, though, that when you asked that question, my client was already under arrest, correct?
He was detained.
Okay, so he wasn't under arrest?
Like I said, I'm not sure at that time.
Okay. Who detained him then?
My partner.
Okay. So you'd rely on whatever your partner stated was the time of arrest would be the time of arrest?
Yes.
Okay, fair enough. And fair enough to say that when you asked for that date of birth, that my client was already in handcuffs?
Yes.
When this interaction started, you were the passenger in the police van, is that right?
Correct.
And you noticed the light and the firearm and then went to speak to my client, correct?
Correct.
And you stayed seated in the car?
I did.
And that interaction lasted at least 2 minutes, correct?
I'm not sure.
So for an officer, if you feel under threat, you want to get on your feet, you want to get out of the car, correct?
I would assume so.
Okay, and that's fine. In this case, though, you didn't feel that threat where you want to get out of the car to make sure you're on your feet when you first spoke to Mr. Taylor, right?
Correct.
We can rewind the video if we need to, but I'm just trying to speed it up. While you were sitting in the car, did you or your partner even say to my client, look, we don't think it was intentional what you did. You just act like an idiot, so to speak.
I don't recall.
Okay, you don't, fair enough. As your partner was the arresting officer, you agree he decided the charges and what to move forward with, is that correct?
Yes.
And of course, that was in consultation with a lieutenant and 2 sergeants, correct? Correct. Nothing further, Judge, thank you.
Thank you. Any redirect, Ms. Horn?
no, redirect, Your Honor. For Officer Ellis, thank you.
Thank you. Thank you for your appearance, Officer Ellis. You're excused. You're welcome to remain if you wish to do so. Since you've already testified, you can stay in the room. All right.
I'd like to call our next witness, which would be Officer Alex Smalley. He would have been the intoxilizer.
Thank you.
Judge, I would object to this witness this time. The intoxilizer is back at the DDC. The purpose of this hearing is whether it's probable cause to arrest. That comes way after an arrest. And so I don't think it'd be necessary for this probable cause determination.
Thank you. Did Officer Smalley administer the PBT on the scene, or are we talking about the intoxilizer back at the station?
The intoxilizer back at the station, but we do have Sergeant Rabior who did administer the PBT, Your Honor, if that will be admitted by the court.
All right, thank you.
I think that would be relevant to this determination.
All
Yes,
right,
Judge.
thank you. I would agree. I think the PBT testimony is relevant to the determination today.
Okay,
I'm not sure the intoxilizer is, and so I'm going to sustain the objection on that one, but the PBT, I do think is relevant.
But of course, Judge, if we're moving to, when this is done, if we're moving to civil infraction hearing, obviously she might need that witness. So I don't want her to excuse him. The one we objected to, if you need him for a potential civil infraction hearing, keep him on standby.
Oh, yes, absolutely. Okay, and I think, what we have, I believe that Sergeant Willie Robinson, he's the one who did the PBT. I think I kind of smoothed through that because I didn't think that the court would allow the PBT to come into testimony. Not sure if that's the same for evidentiary or trial, but it wasn't.
No, Judge, in all fairness, for a PBT in this case, I'm judging, or I'm going to argue that there's no probable cause at time of arrest. The PBT even came after that arrest, even though potentially trial, it may be an issue. And obviously, from our discussions, and we know from discovery that that wouldn't have led to probable cause because it wasn't at least a .08 on the scene. So I have no problem if she doesn't have to testify. I'm good with that.
And I think for now, for purposes of probable cause, we're going based on the civil infraction as amended. And if council has any further argument, the people at this time, we do believe we've met our burden by a preponderance of the evidence that there was probable cause to arrest Mr. Talley. It was found, they believe that he had brandished a gun to point right at them. This was testified by Officer Stearns and Officer Ellis. And in addition to that, it was determined at that time, based on the smell of alcohol, that he may have been under the influence. How much BAC, we're not sure. Blood alcohol level, we wouldn't know. But Officer Stearns did testify credibly to the smell of alcohol on the scene at that time. I think it's this time the people believe that we've proven, at least our smaller burden, not beyond a reasonable doubt, but the civil burden, that there was probable cause, and also to continue with formal hearing on this.
All right, thank you.
And Your Honor, obviously we oppose that. Let's just look at what we heard in this hearing. We heard Mr. Talley, assuming everything's true, that the prosecutors presented, all the witnesses are completely true. Let's take it all at their word, exactly at their word. We still win. First, basically they're saying Mr. Talley was pointing a firearm, he's being an idiot, basically. It was not good, it wasn't the safest thing to do. And I get that, I understand that. But what's very clear in this whole case is, was there probable cause to make an arrest? Let's look at things. First, the two officers are in a car. They pull up to these subjects. They don't get out of the car. They don't get on their feet. They sit there for, well, he doesn't even recall how long. They have a conversation on their tushies or on their butt, basically, in a car. If officers under threat that they're going to get shot at, they're getting on their feet. Now, of course, I'm not an expert in this by any means, but in my 15 years, you get on your feet. They did not feel threatened by Mr. Talley at that point. They were just trying to have a discussion. What made them upset was when my client gets argumentative. That makes them mad. And I get that. I watched the video. I was an officer. That teed me off too, right? I'm just trying to make a point and move on and be done with it. That's what they were doing. And I'm not faulting them for that. But that doesn't make it a crime. When it becomes a crime is when they're upset and say, hey, look, they're not getting my point. I get where they're at with that. I do. Then they say, we're going to look at this a little bit further. Pull the van over, they get out, then they start having a discussion with Mr. Talley. What does Officer Ellis do? He actually has my client retrieve the firearm from an SUV. So if an officer feels under threat, they're not going to say, hey, go put your hands on that firearm, sir, and then go ahead and hand it to me. They're going to retrieve that firearm themselves. I found it interesting, though, that the officer testified before the objection came out and I moved on. He said if it was a domestic situation and the gun was in a dresser drawer, he would probably ask them to go get it. Okay, fair enough. That's him. I understand that. You are not feeling threatened by any means. Okay, so that's the facts we have. Later on, there's a PBT. It was pulling some teeth for the officers to admit when my client was under arrest. They seem to be very afraid and skittish around that issue. Both of them. When was he under arrest? We're trying to work around this because their case is weak. There is no probable cause. Now, let's look at that. The second one, Officer Ellis testified. He relied on his partner's decision. He was the primary officer. He's the arresting officer. It's his decision. Fair enough. I understand that completely. But let's look at what we have. We have the first statement within a minute of this incident, and from that chair, the officer in charge admits, we didn't think it was intentional or anything. He says it, he states that he stated on that date, and he confirms it under oath, which I get. They didn't feel threatened. Totally understand that. But then I go over every possible charge they could have arrested him on. What charge did you arrest him on? Felonious assault against a police officer. Fair enough, felonious assault. So let's take that. We know that felonious assault under 750.82 requires a dangerous weapon and an assault. What is required for any assault in Michigan is common case in law, intent. The officer said on the video and confirmed under oath, we didn't think you intended to do it or anything. There goes their case, gone. It's over. I went through every other charge they tried to post hoc come up with. Well, he's intoxicated. Well, we didn't have the PBT at that point. Well, this and that. Nothing to show a PBT shows a point of weight, which is what's required to make intoxication while in possession of a firearm. It's to make that charge, you need 0.08 or more. They said, well, we think he's under the influence, which I get. They smell alcohol, he comes back with something. And then later at the station, there's something. But no, there's no testimony, it's a 0.08. So let's take that charge. That's what the ticket was written for originally. That's gone now, we know that. That's gone. That was a defect. It doesn't even, the government had to dismiss that or amend, which we had no problem with, amend it to a civil infraction, because they have to admit, there's no probable cause on that. Let's go to the third one. What was mentioned today, let's also look at what was mentioned in the people's response. It says, well, they had probable cause because it's brandishing a firearm. Okay, just because you have probable cause of one thing, you could have it for something else, which I get. But brandishing a firearm in Michigan, was it required? Intent. And actually, I'm just going to quote from the jury instruction. Brandishing a firearm. Michigan Criminal Jury Instruction 11.25a. Defendant is charged with a crime of brandishing a firearm. To prove this charge, the prosecutor must prove the following. First, defendant possessed a firearm or had control of a firearm. And of course, it defines a firearm as a weapon that will shoot out a projectile by explosive action, is designed to shoot out a projectile by explosive action, or can readily be converted to shoot out of a projectile by explosive action. Okay, cool enough, fair enough. Possess, they got it. Cool, I'll give them that. Probable cause, they got it. Second, that while possessing or controlling the firearm, the defendant was in a public place. Give it to him. We're sitting here learned, right? Not a problem. That's out in public. Third, while possessing or controlling the firearm in a public place, the defendant deliberately pointed it, waved it about, or displayed it in a threatening manner. Okay, I don't think we can even say it's threatening given their testimony, but it's okay, Judge. We can actually give them that one too. Let's go to the last one though. Fourth, that when the defendant pointed, waved about, or displayed the firearm, he did so intending to cause another person or persons to be fearful. Intent is required. What is the statement from the grand arresting officer? We don't think there was intent or anything, and he confirmed it under oath. We went through every possible charge that they could have had for probable cause to make an arrest. I even nailed it down several different ways and said that was the only charge, was felonious assault, correct? Yes. There's no disputing that. There is no probable cause to arrest my client. Would there be cause potentially to write him a citation on the alcohol thing? Yes, but that's not for arrest. So I'm asking this court to rule that there was no probable cause to arrest my client. Therefore, anything that was taken fruits of that unlawful arrest, such as an Intoxilizer 9000 at a station, would certainly be suppressed. That is governmental action. Now, of course, as an officer of the court, that's a civil infraction, so the rules get a little bit looser for civil infraction with respect to the exclusionary rule, but this is considered quasi-enforcement. This isn't code enforcement, so your grass is too long and I took a picture in the backyard when I trespassed. This is an arrest where he's deprived of his freedom, not only that night, until the next day. And so, Judge, we believe that any evidence of Intoxilizer 9000 would be suppressed too, but first and foremost, there's no probable cause. And so we would ask that this court make that finding. I think it's not even close call in this situation. Thank you, Judge.
I will allow rebuttal if you have any. Do you have any other statement you wish to make to the court? Ms. Warren?
In closing for the people, I believe there is probable cause here. He was suspected of being under the influence of alcohol during this investigation. He was in possession of a firearm, and I believe that is the probable cause necessary to prove this ticket on the civil infraction that he was under the influence. He smelled of alcohol. He did test his alcohol at PBT at that time for 0.06, I believe, and at the DDC. Now, what's going on at the DDC is not necessary at this hearing today, but for purposes of this civil infraction, he was above a 0.02, Your Honor, under the influence. And not only did he have the rifle that he allegedly pointed at the officers, he also had another gun or firearm that he had failed to disclose to the officers altogether until a pat down. This community deserves better, Your Honor.
Anything further, Mr. White?
It does deserve better. It deserves a better investigation and deserves better enforcement. I don't fault these officers one bit. I did that job. I don't fault these guys. They're trying to be safe. I get it. They're under tough circumstances, but it still doesn't rise to the level of probable cause in the situation. It just isn't there. If we want to talk about the reason for an arrest could be under the influence, there's nothing in this record to say there's a 0.08 on a PBT or otherwise. And even later, well, we're not even at that point. So there just isn't probable cause here. I'm not attributing ill will towards these officers and that they were trying to do anything evil by any means. I think they were trying to educate Mr. Talley. That didn't go so well. And so they made their point another way. Fault them.
Right.
But that doesn't rise to the level of probable cause.
Right. Thank you. There's a reason that we have a probable cause standard. And that standard is that it must be based upon a reasonable suspicion that a particular crime has occurred or is about to occur. Here, it's obvious that the particular crime that was being alleged was the use of the firearm, a felonious assault, the use of a firearm on in the felonious assault of a police officer. I will say, I find the officers to be credible in this case. As I watched, although it's not part of the record, you know, both attorneys in the court have watched Officer Stern's body cam video, as well as now Officer Ellis's. What occurred to me in watching that video was that given the number of officers that converged on the scene, it became almost like a game of telephone, where the first person to encounter says one thing and that starts to balloon out to something else. What seemed to be communicated by Officer Stearns, who was one of the first on the scene, certainly, it's not as clear to me from Officer Ellis, but that the firearm was being handled in some way. And in the handling of that firearm, sounds like from the testimony today that the light was initially pointed at feet, came up and around as it was being placed back in the vehicle where Mr. Talley had to retrieve it from. That's borne out in the officers' statements that they did not believe the aiming of the firearm at them to be intentional. However, on the scene, things started to change because now the allegation is going through various officers. And it starts to kind of take on a life of its own. And Mr. Talley then ends up in handcuffs, arrested on suspicion of felonious assault on a police officer pointing a gun at them, even though both of the officers first on the scene said that they did not believe there could be an intentional aiming. But he ends up in handcuffs, not free to go, as Officer Stearns testified, in a van. And what this court finds to have been under arrest. Officer Stearns said that he would have considered it to be under arrest because he was not free to go. And Officer Ellis said, well, whatever Officer Stearns says. If he says that's when it occurred, that's when it occurred. So clearly here, the arrest was for the felonious assault on a police officer. I know that there were some other cases running along with this. The court has had trouble, quite frankly, making sense of them because the register of actions contain all kinds of different weird dates about the date of offense. But what we did pull was that it would appear, although it contains a different date of offense, I don't know why, that there was initially a charge for fingerprinting refusal as to Mr. Talley. Don't know if that was the same case. Okay, but that one was dismissed for compliance. I then had another case where Mr. Talley was charged with, looks like an assault and battery, found not guilty by a jury. Again, I can't make sense of the offense date in that file. And then I have another case from 2025 where I can't even tell exactly what the disposition is here. The latest thing I can see is an October 29th entry there of 2025, and then nothing further, no final disposition. I'm sorry. I am looking at an October 27th date in 2025 where there's an order of dismissal. So, you know, I don't know if any of those others are riding along with this one, given some of the allegations that were made. But given what I think is the officer's, quite frankly, very credible testimony, I do not believe that either of the officers perceived a threat to them at this time, an intentional threat. Again, borne out by the statements, borne out by asking Mr. Talley to retrieve his own firearm and hand it to the police, you know, and perhaps this is what would happen under the same circumstances. I don't know. You know, as a layperson, you know, familiar with the law at least, but not an officer, certainly I'm not going to ask a person who I feel is a threat to me to go and grab a firearm. I mean, that's just a logic. So at this time, I do find that there was no probable cause for the arrest for felonious assault on a police officer, given the officer's testimony today. All right, now, where does that leave us as to where we go next, right? Because ultimately, Mr. Talley is charged now with a civil infraction because the court granted the government's motion to amend the ticket to a civil infraction. It was initially charged as a misdemeanor. But under the statute, Mr. Talley would not have been charged with a misdemeanor. That would have been an improper charge. So where do we go from here? Is there fruit of the poisonous tree? Does the exclusionary rule apply? So what the court started trying to look at was, would there have been an inevitable discovery of this and under different circumstances? Here, there was some statement after Mr. Talley was already arrested that there was the smell of alcohol. However, there was no additional information even there about, and there was extensive contact with Mr. Talley about slurred speech, about glassy eyes, about any of that, right? And so then we have to determine, would there have been probable cause to subject Mr. Talley to a PBT and ultimately an intoxilizer, given that there was not probable cause to arrest him for felonious assault on a police officer. Mr. Talley was in close proximity with at least 2 other people. He was in close proximity to a vehicle where there could have been alcohol. And so, the court is having difficulty seeing how Mr. Talley would have gotten to the point of a PBT or an intoxilizer absent the arrest for the felonious assault on a police officer. And so the court is finding that the exclusionary rule does apply and that the PBT and intoxilizer are suppressed, leaving no evidence of Mr. Talley's consumption of alcohol, intoxication, etc.
And Your Honor, just a point of clarification, are you stating in this case that the exclusionary rule is applicable to the civil matter that is currently pending as amended?
I am. Thank you, counsel, for the question. I am. I spent a long time, about 5 years, signing search warrants in DUI cases in the middle of the night, which I didn't like, but I did. And, that is one of the things that we're looking at. Like, what is the totality of the circumstances that would lead to this person being breathalyzed? And we are looking for things like glassy eyes and slurred speech and difficulty with a field sobriety test. Right now, saying, well, I think I might have spelled alcohol when I was talking to him. With nothing more, I'm just not finding probable cause there to have subjected Mr. Talley to that testing. So again, yes, the court is finding that there was not probable cause to arrest in this case, that the exclusionary rule does apply, and that the evidence of the PBT and the intoxilizer is inadmissible.
Thank you, Judge.
Thank you.
Given that still leaves us with the firearm issues.
Correct.
Defense would renew its motion that my client filed pro se or improper prior to my appointment or involvement in this matter. There is no conviction. Sister counsel, prosecutor provided their updated policy. There is no conviction. I think even on their own policy, Detroit Police Department would agree that return is appropriate. And I would just ask that the court order that. I would ask that the court just kind of infinitely hold that show cause in abeyance, because if they comply, they should have an opportunity to comply, Judge, before we would deal with that.
Thank you. Attorney Horn?
I will defer to the court in this matter, except for just for the record, the people believe in generally in civil cases, the exclusionary rule does not apply because it is applicable to search and seizures under the Fourth Amendment protections. But the analysis that Your Honor was speaking of was based on the totality of circumstances. By preponderance of evidence, more likely than not, we're not sure whether or not Mr. Talley was intoxicated by smell alone. And that's how I'm taking that interpretation, Your Honor.
Thank you for the clarification.
Yeah, just to make sure the record's completely satisfied, it's been used in civil asset forfeitures because it's quasi-criminal, even in some torts actions such as car accident cases. And in the one of 1958 Plymouth Sedan versus Pennsylvania, 380 US 693, which of course also comes in forfeiture of $176,590 at 443 Mish 261. Of course, this isn't civil forfeiture, but it has also been recognized in Long Lake Township versus Maxon. That's a civil context, 513 Mish 101 of 2024. It did apply to some warrantless blood draws in a negligence context even. I think in this case, it's obviously quasi-enforcement as a civil infraction, and it would apply. I understand the court's ruling. I'm not arguing either way. Sister counsel want to make the record complete, and I want to make sure it was complete too.
All right, thank you. Thank you both for the clarification. Okay, now, next question is, do we know where all of Mr. Talley's property is?
Yeah, that witness would be called.
Yes,
right?
people would ask, the court call, Captain, Cameron and, with properties, and if she could be assisted by one of the other officers.
All right, thank you. All right, we will consider this in a continuation of the motion for return of property so that we
Okay,
have
thank
a
you.
record to attach this
Appreciate that.
officer's testimony to. Okay,
And
thank you.
can the people take a brief recess just for 5 minutes?
Sure, yes,
So they know what procedurally has occurred.
yes. Thank you, officers.
Thank
Really
you.
appreciate your appearance.
Under Michigan law, this case involved allegations of felonious assault on a police officer and carrying a concealed weapon while under the influence. The central legal issue was not simply whether a firearm was present, but whether the prosecution could prove the required criminal intent for an assault offense. Under Michigan Penal Code Section 750.82, felonious assault requires an intentional, unlawful act that places another person in reasonable fear of an immediate battery. The defense challenged the probable cause behind the arrest, arguing that the officer's own testimony showed they did not believe the firearm was intentionally pointed at them or used as a threat. The court found that the officer's statements created a significant problem for the prosecution. Their testimony indicated they did not believe Mr. Talley intentionally aimed the firearm at them, and the circumstances did not establish the intent required for the assault charge. Because the court determined there was no probable cause supporting the arrest, the resulting evidence obtained afterward was subject to suppression under the exclusionary rule. This included the alcohol-related testing evidence connected to the operating under the influence charge. Under Michigan law, evidence obtained after an unlawful arrest may be excluded when it is considered the direct result of that illegal police action. The final ruling was not a criminal conviction or sentence. The court suppressed the challenged evidence, dismissed the unsupported charge, and ordered the return of seized firearms and property. The case ultimately turned on a basic criminal law principle. The prosecution must prove every required element of an offense, including intent. When the officer's own testimony failed to establish that element, the defense successfully challenged the foundation of the arrest.